afternoon to you all. Welcome to Asake Online. My name is Zenzele Ndebele. I'll be the host for this public lecture. For those who are joining us on Twitter Spaces, it's a good afternoon to you. I hope we'll be able to get the sound as well from our Zoom link, and we'll be able to connect with you. So the main purpose of this lecture is to just talk about Gukurahundi and the international law. There's a lot that has been said locally about Gukurahundi and the international law. Sorry about that. We seem to be getting a bit of feedback on Twitter because of the microphone. So maybe we can just hold on a second. We seem to be getting a bit of feedback on Twitter. So I just want to figure out where that feedback is coming from. Then we start. Okay, I think it's a bit sorted now. So like I was saying, we'll be having this on Zoom as well as on Facebook. And we hope to have it on Twitter Spaces as well. So today is the 20th of January. It marks 39 years since the Gukurahundi was deployed, and exactly on the 20th of January 1983, Gukurahundi was deployed in Matabele North, Cholocho, Nkai areas, Lupane, and what followed was a genocide that we are now talking about. People were massacred, and over the years we've been talking about this issue, but today we want to reflect these atrocities that happened. What does that mean at international law? And who is the best person to talk about this other than a human rights lawyer, Siphosami Malunga, who has also, in his capacity as a lawyer, has dealt with these issues at international level and is going to share with us his experiences and also the legal opinion of Gukurahundi at an international level and what does it mean for international law. Mr. Malunga, the floor is yours.
Thank you so much, Zenzele. Can you hear me? Okay, great. I hope that your Twitter followers can also hear me as well. I'm sorry about this microphone issue. I hope that it will not impact on our lecture today. So I'm really appreciative of having been asked by SITE to speak on this occasion, which is by no means an insignificant occasion in the history of our country. Many who may not have been born then or who may not know what happened in Matabeleland and the Midlands in between 1983 and 1987 would be easily forgiven to believe that it is impossible that such things did happen. But I want to move away from a narrative that has existed for a long time, and a factual narrative, a narrative, an experiential narrative, a narrative that doesn't really look at the legal aspects of Gukurahundi. I came to this space where I am now in a very interesting way. Obviously, many of you who may know my history will know that my father was a senior ZAPU official at the time of the Gukurahundi, and he himself was a victim. He was charged with treason, accused of supporting and aiding dissidents, arrested, detained, tortured, eventually acquitted, but still detained after being acquitted. So I experienced all this as a young little boy. The Gukurahundi experience for me was also a very personal one. I had relatives who were killed. I had uncles who were killed, whom I knew very well, who were my father's friends, like Jinin Tuta, and many others who were fellow parliamentarians. So I experienced this at a very personal and close level on the one hand, And as a little boy living out in Four Winds on the Matopos Road, I experienced the trucks on a daily basis going to Balagwe, the military trucks. They would pass there. And oftentimes my father would be in jail at the time, but we were little kids and would see these trucks with these red berets, soldiers, and we knew, and there would be a retreat shopping center. It was just almost like a typical military siege. So that's my first experience of Kukraundi. My second experience of Kukraundi was when I was a young aspiring law student, when I volunteered at the Bulawayo Legal Project Center, which was then run by David Barron, David Coulthard, under the auspices of the Legal Resources Foundation. And there we embarked on a project of documenting the atrocities, and under the able leadership of Barney Greenland, and of course now the late, I say late because he disappeared, never to be seen again, Paul Chizuze, who was a paralegal, worked under his wing on a daily basis, sitting down and taking notes from victims who came from the rural areas, just narrating their experiences. And these reports would culminate in a report, Breaking the Silence, which was authored by the very highly capable and committed Shari Apple, whom you may know, of Ogotula Trust. So that was my second experience of Kukraundi. My third experience of Kukraundi, almost vicariously, was when I then left the country and went and worked at the United Nations. Zanzele, you might want to check. It says your the space has ended. I don't know. That's something that you might want to check.
We can't hear you on Twitter because we couldn't accept you as a speaker. So the people on Twitter can't hear you.
Okay, no problem. So I'll just continue here then. So my last. So my not last, really, my third encounter with Kukraundi was almost vicarious. You may still invite me, then I'll try and join again, and let's see, maybe this time it will work. But my third encounter was almost vicarious when, as a young lawyer, having left Zimbabwe and having joined the United Nations, I found myself thrust right in the middle of unbelievable work on helping a country, a small young country, come to terms with its violent past. This was in East Timor, where we had to set up a tribunal, modeled on the International Criminal Tribunals to try what were very serious crimes that had happened over many years in that country, and unexpectedly, I found myself, and you may not believe this, I found myself on the other side. And when I say the other side, I found myself defending perpetrators of serious violations of human rights. I was one of the few young criminal lawyers there, and it actually ended up just being like that I ended up being one of the senior defense trial attorneys there. And I defended the first militia commander who was charged and tried for committing crimes against humanity. His name was Johnny Marcus. You can Google him. The case is reported and it is available online on the web. He was charged, he committed the massacre of 9 members of the clergy in a place called Los Palos. He killed all of them in an ambush and threw the nuns into a ditch, into a river. The most gruesome murder. I defended Johnny Marcus and several of his gang. He was the militia commander of a militia group called Team Alpha. I went on to defend many others. He was, of course, convicted, not less because I didn't defend him well. I did my best. I believe I did more than my best because I was really committed to ensuring that he had a fair trial and that the prosecution, which was very strong compared to the defense because they had all the resources from investigators to police to witness protection. I was quite intent on ensuring that the trial was fair and that the prosecution substantiated all the allegations they had against Johnny Marcus. I then went on to defend many others. I'll run through quickly because our subject matter is Burundi, but it's important for the audience to understand my interest in this, and I know that it's been perverted by many detractors who try to politicize this, who forget that it is not only in Zimbabwe that these things have happened, and it is not only in Zimbabwe that we've worked on these things, on these issues. So in that particular context, I went on to defend many other militia commanders who committed really gruesome acts, and I think successfully so, because my point was to ensure that they had fair trials, that they had the equal protection of the law, and that the state was able to substantiate the allegations against them. I was not willing to accept that they be lynched simply because atrocities have happened, that everything that has happened in a particular village or district is attributed to what then was my clients. And I was keen on making sure that that criminal process was meaningful and fair and just to the accused persons. So that's how I come at this. And then, of course, I have continued to be interested in Kukuraundi. But one of the things that I realized coming back from East Timor was that there was a huge gap in our discourse on Kukuraundi. And that gap was in some way, not in a huge way, but in a very meaningful way, filled by Dr. Mkhululi Nyati in his article with Kilanda, where he deals with the issue of accountability for Kukuraundi, but from a legal perspective. Much of the discourse on Kukuraundi has been factual. And a lot of the whether it's scholarly attention has focused on issues around reconciliation. Some of it has focused on issues around memory, how to address issues of memory. A lot of it has also focused on issues of trauma, intergenerational trauma, etc. But what has been missing in the discourse of Kukuraundi is the law. What does the law say? And I know that a number of people have raised this issue, including not least, of course, Chief Ndiweni, who at some point with a number of other chiefs wrote to the United Nations, I think, saying, well, what is the UN going to do about this? But I think for us lawyers, we've been quite derelict in our responsibility because when all is said and done, when the politics is done, when the noise is done, the question is, what does the law say? What does the law say about anything, about everything? And I'll try and talk through the law, not the politics, not the narratives about 2023, not the narratives about a political conspiracy. What does the law say about Kukuraundi? Because the law does say something about it. The law says something about everything. As a matter of fact, all you need to do is to look at what is the law, and how does the law apply, and what are the implications of the law applying on a particular situation. And that's where I'm coming at this from. And I hope that in some small way, it will contribute to a better discussion and discourse of Kukuraundi. One that is not captured by emotion, one that is not, and I'm not criticizing emotion, one that is not captured by arrogance, by ignorance, and by foolishness that we see sometimes on all sides of this debate. So as a starting point, my lecture has 5 parts. I'll really try and be quick because we've lost a bit of time. So the first part will deal with the applicability of international law to Zimbabwe. That will be very quick. The next part will look at the status of international criminal law in Zimbabwe. What's the status of international criminal law in Zimbabwe? The third will look at the status of the conflict in Matabeleland under international law. This is beyond the dissidents did this, the Ndebeles did this, the Shonas did this. No. What is the status of the conflict under international law? What does international law say about the conflict in Matabeleland? The next part of my lecture, I'm going to evaluate the Bukuraundi atrocities themselves under international law. I'm not going to go into great detail, but I will talk about what does international law say about the Bukuraundi atrocities. And then finally, I'll talk about the implications of all this. And of course, on the implications, I'm going to talk about issues related to individual criminal responsibility and the national and international duty to investigate, prosecute, and punish perpetration of international crimes, which I will have shown will have been committed at the end of my lecture. So we start now with the question of the applicability of international law to Zimbabwe. I'm going to try, because I realize that my audience is not lawyers. So I'm really trying to balance here a conversation that's understandable, that's comprehensible to my audience, but also that captures in the essence of the law in a way that it is rigorous and honest and reliable and dependable. And in some instances, I'll talk about some cases. They may not make any sense to a non-lawyer, but they do indicate, the basis and the sources on which my arguments, I rely for my arguments. And I hope that will be helpful. And for lawyers who want to have a separate and more in-depth discussion, I'm happy to share a more elaborated paper on this. I'm working on a project on this anyway, so there'll be more time and other opportunities to discuss this. So, what is the applicability of international law to Zimbabwe? This case has been settled, and it is captured in the supreme document of our country, the supreme legal document of our country, which is our Constitution. Our Constitution, at Section 26, provides that customary law, customary international law, is a part of the law of Zimbabwe. Lock, stock, and barrel, the Constitution imports all the rules of customary international law into our law. And it says that only if it is inconsistent with the Constitution or any act of Parliament, then there's an exception. But it's clear. And I'm going to distinguish customary international law and other forms of international law. So that debate settled by our Constitution. And this has been reaffirmed by a very brilliant judgment from Chief Justice Malaba and his colleagues in the Supreme Court before the Supreme Court and Constitutional Court were split, 2018. In a case called Minister of Foreign Affairs versus Michael Jenrick, Standard Chartered Bank and Sheriff of Zimbabwe. Lawyers or young lawyers or aspiring lawyers can take time to read that case. It deals extensively with the applicability and the application of international law to Zimbabwe. The second important, so basically all customary international law applies to Zimbabwe. It's part of our law. Remember this, because I'm going to be talking a lot about customary international law as I proceed with my lecture. And whenever I say something is customary international law, then you must conclude that whatever is customary international law applies to Zimbabwe unless it is inconsistent with our law, with our constitutional act. So it's a very important provision in our Constitution, this one. And of course, there's legal precedence around on this issue that if a customary international law provision is violated, it does not necessarily mean that it removes the existence of its customary character. There's a case in Nicaragua versus the United States of America. It was in relation to the paramilitary activities in Nicaragua, including by the Americans. So, apart from customary international law, Section 27 of our Constitution of Zimbabwe provides that all treaties, international conventions, agreements that are binding on Zimbabwe are applicable in Zimbabwe, right? So Section 27 provides for the applicability of treaties, conventions, and agreements. But there's an exception there. Only if they are approved and incorporated into law. So many of you will ask, well, we understand that there's this convention on human rights, there's this convention on genocide, there's this convention on this. Isn't Zimbabwe bound by it? Why can't we use that convention? Why can't we look at the convention? The law is very clear on this. Our constitution is clear that all treaties, conventions, and international agreements are not binding on Zimbabwe unless they are approved and incorporated into the law. Unless, of course, that treaty says there is no need for that to happen. There's something interesting, though. I believe it was in 2000 and, gosh, I'm trying to remember the amendment, Act 12 of 1993, I believe, which was really an amendment of the old constitution, which was Section 111B, which incorporated and many of the treaties that had been signed before, and made it not necessary for Parliament to approve. It's somewhere else in my writings, but it's important to think about that, to think about Section 11B, the old Section 11B of the old Constitution. But for now, the most important thing to remember is that a convention is applicable in Zimbabwe only if it's binding, only if it is approved and incorporated into law. Section 327(6) of the Constitution provides, in fact, directs our courts to interpret all legislation in consistency with international law. This is important, all these provisions, because they paint a picture of the importance of international law to the country, that the framers of our constitution were very concerned and preoccupied that Zimbabwe is seen as obliging and complying with international law. So courts are implored to interpret. There have been many cases on this, not necessarily in Zimbabwe, but one of the fascinating cases on this issue, it comes from South Africa, which has exactly the same provision in its constitution as the Zimbabwean one, except for a minor difference. A case called Glenister. Those of you who follow South African politics and law will remember the case. It was about the scorpions and all this. When Zuma closed down one of these investigative elements, it was taken to court. There are many other cases. The Bashir case also deals with this issue, which is Southern Africa Litigation Center. And then there's a number of other cases too. So that is the status. That's what the Constitution says. International law applies to Zimbabwe. There's no debate, there's no discussion. That is our law. The second point I need to discuss is what about international criminal law? Because remember that international law has many elements. There's international private law, there's international criminal law, there's international trade law. There's many different aspects of international law. International criminal law, on the other hand, deals with those rules in international law that seek to prohibit, punish acts that are deemed by the international community as crimes. And I'll talk about this later, not really now. I'll talk about what are international crimes. How do you distinguish them from national crimes? I'll discuss this. But the point is fundamentally this. International criminal law is encapsulated in a number of sources. One is customary international law that I spoke about earlier, which is a part of the Zimbabwean law, according to our constitution. So some of the foundations of international criminal law are actually customary international law. So you can go to customary international law to find what the international criminal law is and what it says about the different things. The second source of international criminal law are treaties, conventions, and agreements, the ones that I've talked about, that I say that they're only binding if and when they've been approved by Parliament and incorporated into law. Now, I'll start off with conventions. What conventions apply to Zimbabwe that are relevant for international criminal law? The first is the Geneva Conventions of 1949. And of course, those of you who follow the history of the world will know that the Geneva Conventions were passed in response to the Second World War, after the atrocities that came out of the World War, just the barbarity, the lack of rules and anything in terms of fighting the war. The international community came together to craft some rules, clear rules about how conflict should be regulated, things that are allowed or permissible in the conduct of hostilities between states or even within states. The law evolved to look at internal armed conflict subsequently, but the Geneva Conventions ostensibly sought to regulate armed conflict, to restrict certain conduct, to prohibit certain conduct, which had been seen and observed in the Second World War to be completely undesirable and utterly disgusting and despicable, in fact. And not least, as you know, the massacre and the Holocaust of the Jews in Germany. So the international community came together and said, hang on, we need to stop this. We need to regulate how wars are fought. The international community was not willing and ready at the point to outlaw war because war, as they say, has been always a form of diplomacy. They were not willing to say, we want to make war illegal. They're saying, no, we want to make sure that when people fight, they fight properly. And that's when they had a string of conventions that outlawed certain things. And the 4 Geneva Conventions, you can go and look at them. I'm not going to name them. Each and every one of them. Some deal with protecting people at sea. Some deal with prisoners of war. Some deal with protecting civilians. And so on, or the responsibilities and duties of people in occupying territories. Because remember, during the Second World War, there were so many occupations in France, in Switzerland, and so on by the Germans. So the question, we need to restrict and regulate the responsibilities of people who occupy territories. And the same, I mean, it applies if you think about Israel and Palestine right now. Those rules apply. If you're an occupying force, the Geneva Convention set out what your responsibilities are, what you can do and not do. So one thing for sure is that, Zimbabwe acceded to the Geneva Conventions in 1992. It's a party to them. So one step is accomplished. Zimbabwe is a party to the Geneva Conventions. But also I should say that the Geneva Conventions have now been accepted, many of the provisions there, as customary international law. So remember what I said about customary international law. So there's provisions in the Geneva Conventions, the prohibition against attacking civilians, killing civilians, especially in particular. And there's case law to substantiate this finding. And the most important provision in the Geneva Conventions regarding the protection of civilians is a provision called Common Article 3. And this Common Article 3 is in every Geneva Convention, every one of the 4 Geneva Conventions. And the Common Article 3 really simply stresses that civilians are protected from attack in the course of conflict. Why is this important? It's going to be important later when I talk about and characterize the Matabeleland conflict, whether it was a conflict or not. Then we'll go back to look at what are the obligations that would have existed or that existed with regards to the Geneva Conventions, especially Common Article 3. It becomes important in that scope. Like I said, this is not political. We're making legal assessments and analysis of these issues. And it's important to do that because that's what we did when we were in the courts in East Timor anyway. We put the politics aside and said, what does the law say about this? So Common Article 3 provides, this is common to all the 4 Geneva Conventions, provides for the protection of civilians from attack in the conduct of hostilities, whether internal, internal or international conflicts. Very important. Common Article 3 applies. And Common Article 3 is now customary international law. And this has been reaffirmed by a number of cases, jurisprudence of international tribunals in the ICTY. Those of you who might want to check this, in the case of Tadic, which was the first case which dealt with the jurisdiction of the International Court. Tadic was one of the first persons to be tried in the International Criminal Tribunal of the former Yugoslavia. Blaskic as well, and of course closer home to Africa in the case of Akayesu, who was a mayor in Rwanda. Paragraph 616, those of you who might want to go and check there. And basically, these cases reaffirm one principle, which is that customary international law imposes criminal responsibility for violations of Common Article 3, which, if you remember, I said protects civilians in armed conflict. And of course, there's been a case that has looked at this as well in Rwanda, in the case of Kayishima and Ruzindana. In that particular case, Rwanda was a state party to the Geneva Convention, and the court found that Rwanda was bound by its obligations there. And there are a number of things, a number of crimes that Common Article 3 lists, a number of prohibitions, the things that you can't do. It says you can't attack civilians, but it's more specific. What can't you do? You can't, for example, impose violence on civilians, violence to life, health, physical, mental well-being, in particular murder, torture, cruel treatment. You can't collectively punish civilians. You can't take hostages. You can't take civilians as hostages. You can't conduct acts of terrorism against civilians. You can't conduct outrages of human dignity against civilians. You can't pillage. You can't pass sentences and executions without any judgment or any trial. So there's a whole list in there in Common Article 3 of prohibited acts, which, as I say, Common Article is customary international, and I say customary international law is part of our law. I'm hoping you'll be joining the dots as I keep going. There's another two important conventions, international conventions, related to international criminal law or humanitarian law, if you may call it that. Sometimes they use it interchangeably. It's not exactly. Humanitarian law is usually used in relation to the conduct of armed conflict, but international criminal law is more expansive. It includes the conduct, the expected behavior and conduct of everyone, including outside conflict. That's why you'll see things like genocide and crimes against humanity do not need the existence of an armed conflict, unlike war crimes, which I'll talk about later as well. So, and I hope that I'm not confusing everybody, but I did say that it was going to be a law lecture as well. You can't discuss anything in terms of international law without discussing the law itself. So there's two important additional protocols to the Geneva Convention, the Additional Protocol 1 and Additional Protocol 2. Additional Protocol 1 relates to the protection of civilians in international armed conflict. And it lists all the obligations of states in terms of protecting civilians in international armed conflict. Zimbabwe is a party to the additional protocol. It acceded to it in 1983. I think shortly after Bukurawundi started, in fact. May have been before, but my recollection is that it would have been around March, probably. So that's clear. Zimbabwe acceded to this treaty, the additional protocol. Then there's additional protocol 2, which relates to the protection of victims of non-international armed conflict, which is internal armed conflict. And Zimbabwe acceded to this one in 1992. Many of the provisions in these protocols are considered as customary international law, but not all of them. Not all of them. Many of them are. And one of the critical ones that is customary international law is the prohibition of attacks against civilians. The prohibition of attacks against civilians is a customary international law. It applies whether or not you have signed a treaty, you're a party to a treaty or not. It's applicable to everybody, every country, every state. And then there's another important convention related to international criminal law, which is the Genocide Convention of 1948. It's elementary, I should know this. Zimbabwe acceded to the Genocide Convention in 1991. And in 2000, Zimbabwe enacted legislation, the Genocide Act. So this is an outlier. One of the few international conventions that Zimbabwe has not only adopted, acceded to, but passed a law. And there is, you can read it, the Genocide Act is Act number 9, I think, 920. I could be wrong, but it came into force on 16 June 2000. The law, the Genocide Act of Zimbabwe. Of course, the customary law nature of genocide is beyond debate. It was established and determined in 1951, way back when the convention was passed by the International Court of Justice, which passed an advisory opinion to say that it is now customary international law. And of course, it has been reaffirmed in many cases, many cases in the International Tribunal for the former Yugoslavia, in the International Tribunal for Rwanda, Akayesu case, the Kambanda case. Kambanda was the former prime minister of Rwanda. That case also dealt extensively with genocide. He was convicted of genocide, by the way, and as well as crimes against humanity and other crimes. That's the ICTR, which is the International Criminal Tribunal in Rwanda. That is really all I want to talk about in terms of the applicability of international criminal law in Zimbabwe. So, customary international law provisions that constitute international criminal law are applicable in Zimbabwe. Zimbabwe is a party to the Geneva Conventions. Zimbabwe is a party to both additional protocols. One acceded to just after Gukurahundi started. One in 1992, Zimbabwe is a party to and has domesticated the Genocide Convention. That is the status of the law. That's the status of international criminal law in Zimbabwe. That's law, not politics. The third point I would like to discuss is the Matabeleland conflict. Why is it important to talk about the Matabeleland conflict? It's important for many reasons, actually. Because the nature of the conflict, the type of the conflict determines the type and nature of the responsibility and obligations under international law. As a starting point, for international humanitarian law to apply, which is the law of armed conflict, there has to be an armed conflict. In the absence of an armed conflict, international humanitarian law does not apply. I'll repeat. And when I say international humanitarian law, I'm talking about the Geneva Conventions. I'm talking about the additional protocols. They are only applicable on the basis of a finding that there is an armed conflict. If there is no armed conflict, they don't apply. They were designed and formulated to regulate armed conflict. So it is absolutely critical in determining what obligations Zimbabwe might have had, in determining what violations of international humanitarian law might have occurred, whether any did occur. The right of passage towards that inquiry must take you through a determination of the nature and status of the conflict in Matabeleland under international law. The question of the applicability of international humanitarian law only in instances of armed conflict has been decided and debated in many cases. In the ICTY, in the Tadic case that I talked about, the Foronzia case, Kodic and Cheket's case, which was very clear in defining what an armed conflict is. Tadic case was the first case in the International Criminal Tribunal space in 1994, I believe, to define an armed conflict. And it's a very simple definition. It is the resort to armed conflict, armed force between states. so armed force between states, or protracted violence between government authorities and organized armed groups within a state. Please keep in mind all these definitions, because I'm hoping that you will be making your own analysis and assessments of, okay, does this fit, doesn't it fit? And it doesn't need to fit neatly, because a lot of these findings usually follow an inquiry, a legal inquiry of the facts, and then applying the law to the facts. So I'm not here to hand down a dogmatic position on this is what it is, this is what Gukurahundi is. No, I'm simply analyzing Gukurahundi in the context of international law. And the caveat is that all this would need to be subject to a judicial inquiry anyway. A court would look at the facts and look at the law and then make a determination of whether the law applies and the facts, bear out the law. So one of the important things is that for armed conflict, the victims must be civilians. It is not a crime to kill another soldier in a war. Not at all. That's the whole point. As much as I hate the war, I hate war. You cannot then go and say, hey, you killed 20 of our soldiers, you've committed a crime. No, I mean, that's the whole point of war, right? It's to kill each other as soldiers. But certainly civilians are a no-go. And there's many cases to this: Voka case, Jelisic case, Plaskic case in the ICTY, and of course, Akayesu, Kambanda, Kayeshima, many cases in Rwanda. And of course, the cases in Sierra Leone in the special court there. And of course, in the ICC as well, which is the latest International Criminal Tribunal. So that's the law. There has to be an armed conflict for international humanitarian law to apply. What's the context? What's the status of Machiavellian conflict? And I should say that this is a question that still vexes me. On some days I wake up very convinced, and on other days I wake up thinking, wait a minute, no, maybe not. Was it an armed conflict or wasn't it? There are times when I'm convinced and I have the arguments for it, and there's times when I'm not. And you will understand when I talk about it. So what's the background? There were political tensions in Machiavellian in the country, in fact. And what preceded Gukurahundi, because we must look at the context. We must never forget that there was a context to Gukurahundi. We must not forget that from 1980, ZANU-PF won the election and ZAPU lost and won the 20 seats, mainly in Machiavellian. We must not forget the desire of ZANU-PF and Mugabe to establish a one-party state. We must not forget the role of the Rhodesians to create tension and suspicion between ZAPU and ZANU. We must not forget that the retention of the Rhodesian intelligence people, the Calloways, Matt Calloway, Jeffrey Price, Kevin Woods, all these people who were incorporated into the ZANU-PF new CIO, but who were double agents for South Africa. We must not forget the role of South Africa in all this. That's the background. We must not forget the megalomania of Mugabe and his desire to crush ZAPU and establish a one-party state. That's the context. We must not forget the clashes in Intumbane, 1980, November, and early 1981 in Chitungwiza. We must not forget all this. We must not forget the suspicion. We must not forget the arms caches. We must not forget the sense, right or wrong, perhaps, that Mugabe had, that they wanted to overthrow him. We must not forget the botched assassination attempt. I'm saying assassination attempt because it was reported as such on Mugabe. It was poorly executed, but we must not forget that. We must not forget the attribution of all this to ZAPU. We must not forget, at the same time, the implication of all these clashes and the tensions and the heightened political situation on what was happening in the army. We must not forget that the arms caches resulted in the arrest of the top Zipra generals. We must not forget the purges inside the Zimbabwe National Army of former Zipra elements. The beatings, the torture, and in many instances, the killings of these Zipra forces inside the army, forcing them to defect, to leave, to desert, primarily to save their own lives, but also obviously because they were unhappy. A lot of the issues around the dissidents and the motivations of the dissidents is covered by a very powerful piece done by my friend Jocelyn Alexander. You should read it if you can. It's Dissident Perspectives. It's an article, I think 1997. I'm happy to share subsequently the reference for it if people want to read it. She's also done a brilliant book on Matabele and violence and memory that captures and for the first time it really goes into trying to understand what the dissidents thought, what they felt, what they believed, why they did what they did. My uncle Patisa Nyati has also done a brilliant book on dissidents. And I encourage you to read it if you can. It's a small little book. And then he also traces the experiences of one dissident, Nicholas Nube, I believe. I could be wrong in the name, but I have the book. So if you want to understand the dissidents and the dissidents' perspective, you need to read that. But it's also important to read the perspectives of the government about the dissidents. And you can read the Hansard. You can also read a very powerful thesis, PhD thesis by K. Yap, who writes a lot about dissidents as well. And then, of course, there's many other publications that have subsequently come up. A book by Doran, Dave Coulthard covers it a bit as well. I'm just trying to think who else has written about this issue of dissidents. But there's literature. There's literature on this in a whole range of places. But more importantly, it's important to look also at the report by the Lawyers Committee for Human Rights by Bill Barkley, Wages of War. He covers extensively the issue of dissidents, who they were, what the government thought and said. But I want you to remember a very important point here, which is the role of South Africa. It will become important later, as you will find out. Remember that when it comes to armed conflict, there's two types of armed conflict. There's international armed conflict, which involves more than one state. So it's a state against the state fighting against each other. So an international armed conflict, an example of an international armed conflict would be, gosh, there's so many of them, right? The war in Iraq, international in nature, World War, international in nature, the war between Eritrea and Ethiopia, international conflict because it's two states fighting between themselves. And many others that come to mind. It's important to just say that over the years, the incidence of international conflict has gone down. There's more internal armed conflict happening, even though that has gone down as well in the past 20 years or so. And then there's internal armed conflict. Internal armed conflict is a war within the territory of a state, between the state and organized armed groups. And the requirements for an internal armed conflict have been set out in the ICTR, the Rwandese case of Akayesu, and I'll talk about them. But it's important. I'll talk about them just now. But it's important. The distinction is important that there is an international conflict and an internal conflict, and the elements that bring out an internal and international armed conflict are the involvement of another state. Once there's another state, the conflict becomes international. This will be important for an assessment of what Matabeleland conflict was, especially in light of the role of South Africa. And of course, there is no question. There's more than enough evidence of the destabilizing role of South Africa in the region, not just in Zimbabwe, but in Mozambique. We know the role of South Africa in supporting Renamo, creating and supporting Renamo. And I'm saying this because it's important for context, is to understand the context in which this was happening. So for an internal armed conflict, the requirements have been set out in a number of decisions of International Criminal Tribunal. I'll just cite Akayesu at paragraph 601. It says that there's a number of about 4. So the first one is that the armed conflict must be within the territory of the country, and it must be between the armed forces of the country and a dissident armed force or other organized armed group. That's the first requirement set out in Akayesu for an armed conflict. The second is that the dissidents or armed groups must be under responsible command. Keep this in mind as you do your own analysis of, I'll talk about this, of course, of whether this fits. The third one is that dissidents or other armed groups are able to exercise control over territory to carry out sustained and concerted military operations. And the fourth is that the dissident armed forces or groups or organized groups are able to implement the additional protocol, the second additional protocol, the one I talked about, which protects civilians in instances of internal armed conflict, which Zimbabwe is a party to, by the way, but only after 1992. So one thing for certain is that the nature of armed conflict has changed over time. I mean, Akayesu's decision was handed down over 20 years ago. And the reality is that this was way before we had the Taliban, way before we had ISIS, way before we had all these other different forms of armed rebellions in the countries, even in Mali and in the Congo. But that is the law. That is all the requirements for satisfying an armed conflict. The question of whether the conflict in Matabeleland was an armed conflict or not, an international or national armed conflict, as I said, is not a definitive one. As I said, on some days I wake up completely convinced it was an armed conflict. And when you read the dissident perspectives, and I had this conversation with Jocelyn, when you read her paper and her book, there are elements where she alludes to some level of organization by the dissidents, some level of organizations, and some level of distribution of the responsibilities and operational areas. There's a reference to that in her work, and that persuades me of an organized armed group, the effect that they remained in Matabeleland for the duration, at least until they were captured or surrendered, suggests to me some level of control of territory. And mind you, control of territory does not necessarily need to be full control of territory, because the evolution of armed conflict is that sometimes these rebels, they will strike and go into the jungle and hide. That's exactly what happens now. Contemporary armed conflict in many of these countries, even in the Congo, they don't control the entire territory, but they're able to continue sustaining damage. When you look at the attacks that the dissidents were able to conduct and carry out, there's a couple of fairly significant ones that seemed well coordinated. The attack on Sweetwater, where I think 17 or 18 people were killed on that farm. When you look at the attack, of course, there's many perspectives about whether this was dissidents or pseudo-dissidents. When you look at the attack called Comfort, even though there was some personal nature, there was a land dispute. And when you look at some of the attacks on civilians by these dissidents, you get a sense there was some organization, and at times it was just lone rangers, lone wolves, just angry, scared, also really trying to survive, you know, having left the army. But then when you look at the Super ZAPU, you get a different sense. You get a sense of some organization of some sort, because there's evidence of Super ZAPU having been created after Mark Calloway ran away from here. You remember Mark Calloway is the guy who engineered the arms caches. And then he ran away. He was a CIO. And then he ran away. He went to South Africa. He was a double agent. And when he got to South Africa, he started organizing Super ZAPU. He arranged training by South African National Defense Forces. And this, of course, was affirmed by the government. Then the Minister of State Security, Malunga, talked about this. He even talked about four of the armed camps. It wasn't refuted. So there's no dispute that there was Super ZAPU at some point in time, and that it was under some command of some sort, and that it was able to carry out some attacks. And that it was supported and controlled out of Pretoria. So one has to factor in that in the analysis of whether Super ZAPU was an armed group or not, organized or not, under responsible command or not. And one has to factor in whether the involvement of South Africa turned the conflict in Matabeleland into an international armed conflict. It's a very important point. Because if it did, it kicks in straight away the application of the Geneva Conventions, as I talked about. It kicks in straight away the application of the additional Protocol 1 relating to the protection of civilians in international armed conflict. It's a very important point. And it is not something that one can just write, draw a line across and say, well, it was what it was. It wasn't what it was. We have to come to a clear conclusion about the nature and the status of the conflict in Matabeleland at law. Because the conflict in Matabeleland at law, the nature and the status is important in determining the obligation of the various actors involved in that conflict. Absolutely critical. So there really two schools of thought. I'm inclined, I should say this, I'm inclined to conclude that the conflict, that the Matabeleland crisis or conflict was an armed conflict. And I'm inclined to conclude that the involvement of South Africa made it an international armed conflict. It's more complicated to conclude that the dissidents were as organized, were as under responsible command. But there's some persuasive arguments that are made. I know they're not very developed in Jocelyn's paper. And in my subsequent conversation with her, she was like, no, Sipo, you can't equate this to a conflict. They were not symmetrical parties. And there's no requirement in international law that the parties must be symmetrical. We know that guerrilla forces are usually 2, 3, 4, sometimes 10 guerrilla forces can cause enough havoc. But there will be an armed conflict in the country regardless of the size of the number. So that's an issue that might need to further exploration, and that might need further exploration, and that might need further, analysis of the evidence. But the involvement of South Africa, in my opinion, unequivocally, beyond any question, makes that conflict international. That's my opinion, my legal opinion. And we could debate and argue this. The internal armed conflict aspect of it would depend, of course, on whether one can ascribe to dissidents those 4 critical factors that I highlighted. And in some instances, one might be able to, in some instances, they might not. So that's the position of the status of the Matabeleland conflict under international law. What does this mean? It means that if the Matabeleland conflict was an international armed conflict because of the involvement of South Africa and Super ZAPU, it means that the Geneva Convention applied. It means that the parties to the conflict, including the dissidents and the government of Zimbabwe, was obliged to respect the provisions of the Geneva Conventions in protecting civilians. It means that any violations of the Geneva Conventions constitute war crimes. It's a very important issue. Because certain violations of international humanitarian law amount to war crimes. In particular, violations of Common Article 3, killing of civilians, cruel treatment of civilians, torture of civilians, all those are war crimes according to the Geneva Conventions. So there is an important implication of whether or not Matabeleland was an armed conflict first, international or national. But these are questions that one must look at in trying to find and reach a proper conclusion of what the obligations would be. Then again, if it wasn't an armed conflict, the inquiry doesn't end there. What then becomes of the atrocities? What does international law still say about them? Does it say anything about them or not? That's an inquiry that we are going to go into now. That's the next part of my lecture. When one evaluates the Gukuraundi atrocities under international law, what does one find? And I will talk about the three core crimes of international law. I see many fascinating questions. What does the international law say about pseudo-dissidents? And that's why we're having this conversation, right? We've always had a conversation that's not legal. We're having a legal conversation, and that's what we should be having. That's what we should have had a long time ago. It's a shame we didn't, but that's a conversation we need to have. What does the law say about all this? So then we can talk about reconciliation, we can talk about all the other things, accountability, but what does the law say? So there are three core crimes in international law, international criminal law. And those crimes are genocide, crimes against humanity, and war crimes. I've mentioned a little bit about war crimes, but I'm going to start with genocide. You will remember that I've already said Zimbabwe is a party to the Genocide Convention, which in any case, even if Zimbabwe was not a party to it, the Genocide Convention is customary international law. This matter is beyond debate, is beyond dispute. So you don't need to be a signatory to the Genocide Convention to be bound by it. You are bound, regardless of whether you are, because it is customary international law. But in this case, we've got a bonus. Zimbabwe is actually a party to the Genocide Convention. Not only that, Zimbabwe has domesticated and has a Genocide Act of 16 June 2000. What is genocide? Because for you to determine whether the atrocities in Matabeleland approximate, constitute, or amount to international crimes, you need to do an analysis of the content of the international crimes themselves. Genocide is not a new crime, it's an old crime, one of the oldest crimes humanity has encountered, going back hundreds of years to the Armenian genocide, which the Turkish finally admitted last year, if you remember. Going back to the Holocaust, the genocide of the Jews by the German Nazis. Going to the genocide of Namibians, the Herero, by the Germans, which they finally admitted last year as well. Last year was a year of admission. Genocide is not a new crime. But what is genocide? genocide is captured by the Genocide Convention. The whole crime of genocide is encapsulated in the Genocide Convention, which I repeat, and there's a purpose for me repeating, is also customary international law. Genocide is defined as any of the following acts if they are committed with the intent to destroy in whole or in part a national, ethnic, racial, or religious group. So genocide is a specific intent crime, specialist dollars specialist. But the crime has to be designed or committed with intent to destroy a national group, an ethnic group, a racial group, or a religious group. These are the following acts that are prohibited: killing members of the group, causing serious mental harm, bodily and mental harm to members of the group, deliberately inflicting conditions on the group calculated to bring physical destruction in whole or in part of that group, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. This is what genocide is. And of course, the analysis of whether Matabeleland constitutes genocide must be based on an analysis of this. Does this articulation approximate in some way what happened in Matabeleland? The threshold for proving genocide is very high because it needs you to analyze the objective and subjective factors and the subjective intent of the perpetrators. And of course, the objective elements include the commission of any of those acts, and the subjective elements include you can infer the intention of the perpetrators, which is the subjective intent, the subjective element of the crime. I have come to the conclusion that the crimes in Matabeleland were genocide. And there's ample evidence to prove that and to substantiate that. As a starting point, there was no question that ZANU-PF conflated the victims in Matabeleland were the civilians with Ndebeles. There was always constant reference to Ndebeles. Ndebeles. Mugabe mentioned it. Zobo mentioned it. What's his name? Mukurajija, the commissioner, mentioned it. Nkala mentioned it. The Ndebele aspect of the victims was an overriding and pervasive and constant one throughout. Even when Mugabe was asked, after he had been overthrown in that coup, he was very clear. He said that Ndebele party, you remember, if you listen to that interview, I think it was with either Sky News or SABC, he said that Ndebele party was trying to. So there is no question, none whatsoever, that there was an ethnic element to those crimes. There's many other evidence. Time won't allow us to go into this. When one looks at the behavior of the perpetrators, they were very clear. When you look at the way in which the perpetrators separated people who spoke Shona, spared people who spoke Shona. When you look at the opinions and the views of diplomats at the time, when you look at the debates in parliament at the time, you come to no other conclusion than to attribute the ethnic element to the commission of the crimes. So and there's many examples, I'm not going to give them here because we don't have the time to do that. There is the point I must make. because I've also made the point that Kukuraundi was also about politics. Yes, it's true, it was. I've made it earlier when I said that after ZAPU lost and Mugabe wanted a one-party state. But there's no requirement for genocide to not then have any other elements. So, but political killing is excluded from genocide in the Genocide Act, which is strange anyway. So it means you can kill people for politics and it will never be genocide. But genocide, according to the convention, is national. Kill somebody because of their nationality, their ethnicity, their race, and their religion is genocide. If you kill them because of their politics, it's not. We need to settle this point. And of course, many argue that no, this was not ethnic. This was political. But the reality is different. The reality bears out that it was ethnic. Even in operation, it was ethnic. Because the brigade was Shona predominantly. They spoke Shona. They made people sing songs in Shona. They alluded to Mziliga's crimes. They spared people who spoke Shona. They were very clear. And then there's actually one point where the commander of the 5th Brigade was quite clear about the intent that you will eat your children, you will eat berries, you will eat your cattle, then you'll be nothing to eat later on. There is so much evidence of the debelization of the atrocities. I have very little doubt about that. And we can debate and argue, and I'd be more than happy to engage in a legal argument. And it's a legal argument always, right? So what does the law say? What do the facts say? Do the facts apply to the law? And does the law apply to the facts? So that's where we stand on genocide. And there are many cases, so many cases on genocide, especially from Rwanda, because one of the greatest genocides on this side of the century was Rwanda. Which was really a few years after Kukuraundi ended. You can read the case of Akayesu, you can read the case of Kambanda, you can read the case of Kaishima, and there's many. And of course, this genocide, there's many implicit crimes within genocide. For example, the incitement to commit genocide. And in Akayesu, it was found, following a reasoning in case of Rijiu, which was on incitement. And you may remember, for you journalists, Zenzele and others, that in Rwanda, there were journalists that were convicted for inciting genocide through their radio and their newspapers. And I always remind people when they write things, when they speak, when they say all these things, that you need to be really careful about what you do, what you say. The RTLM, which was the radio in Rwanda, and Kangura, which was a paper in Rwanda, spewed a lot of genocidal speech. And I listen and I watch people on Twitter saying a lot of genocidal things. The incitement to commit genocide is a crime. And Akayesu was found guilty of the crime of direct and public incitement to commit genocide. So were the journalists in the media case in Rwanda. But this was all coming all the way from Nuremberg, where Streicher, if you remember, who was the propaganda chief, the propaganda chief was Goebbels of the Nazi regime, but Streicher was the newspaper mogul. He owned newspapers, and his papers spewed a lot of insightful and hateful speech about the Jews. He was found guilty, and I think he was hanged, actually. He was hanged in Nuremberg for his crimes of incitement. So that's important, and it's important to look back as well at the conduct, not so much of the people who were on the ground killing people, but the people who were spewing hatred, who were spewing hate speech in relation to Kukuraundi and victims of Kukuraundi as well. So I'll end the genocide discussion there, and I'll move quickly to Zonzale. Please remind me how much time we have. I'll try and move a bit faster. I will wind up very shortly anyway. So crimes against humanity is another crime, international crime. And unlike genocide, crimes against humanity is not based on any international convention. There is no international convention on crimes against humanity. There's no treaty governing crimes against humanity like the Genocide Convention or the Geneva Conventions. But crimes against humanity is a crime under customary international law. The absence of a treaty governing crimes against humanity is the subject of a great deal of controversy, because people are like, so what is it? Well, what is the source? If there's no treaty, where did it come from? What is this normative basis? But crimes against humanity, in the absence of these treaties, it has developed over time through conceptual, definitional, and normative articulations by the international criminal tribunals. So notwithstanding that, I mean, the Nuremberg Tribunal was the first in crafting the customary law nature of crimes against humanity, in finding that, and I quote this, crimes against international law are committed by men, not abstract entities. And only by punishing individuals who commit such crimes can the provisions of international law be enforced. And so individual criminal responsibility for crimes against humanity was first affirmed or reaffirmed in the Nuremberg Principles. And of course, it was reaffirmed subsequently in the tribunals in former Yugoslavia, in Rwanda, in East Timor, where I worked, in Sierra Leone, in Cambodia, and ultimately in the International Criminal Court. So that's where we are. Crimes against humanity are international crimes via customary international law. And I've already said that customary international law applies in Zimbabwe via Section 326 of our Constitution. So what are crimes against humanity and how are they defined? And there's a simple definition from the International Criminal Court, the International Tribunal for the former Yugoslavia, which found that crimes against humanity are the factors that go into crimes against humanity: a widespread or systematic attack against civilians with knowledge of the attack as part of the state organizational policy. So there are four factors that make up what is widespread and systematic. And this is very important because as you hear it, you will be able to then draw parallels to whether any of these things exist to constitute, for the atrocities to constitute crimes against humanity. So the factors that are indicative of a widespread and systematic attack, and this is from the judgment in Tadic. The first factor is the existence of a political agenda or ideology to destroy, persecute, or weaken a particular community, coupled with the institution of efforts to implement that policy. That's the first. So these are factors that point to whether there is a widespread or systematic attack to constitute for a crime to become a crime against humanity. The first one is, as I said, a political agenda or ideology to destroy a community. The second one is the involvement of political and military authorities at a high level. That's the second factor that you take into account when you're assessing. The third one is the extent of the financial, military, and other means deployed. And the fourth is the extent of repetitious, uniform, and continuous perpetration against the same civilian population. So that's what you apply in determining whether any attack is widespread or systematic. It's not any crime that's a crime against humanity. If you go and commit a crime somewhere, you can't say, oh, because 100 people were killed is a crime against humanity. Is there a political agenda to weaken a particular community, destroy it, persecute it? Is there involvement of political and military authorities? What is the extent of financial, military, and other means? Is there repetitious, uniform, continuous perpetration against the same civilian population? Those different factors point you to a conclusion whether you have crimes against humanity or not. But the other elements of crimes against humanity also need further elaboration. When we say widespread attack, what is an attack? What does it mean when you say attack? And an attack is simply defined. It is any act, any act, and the acts are enumerated when it is committed as part of a widespread and systematic attack. So anything you do, as long as it is part of that, constitutes a crime against humanity. I'll talk about the enumerated acts. But the attack itself is any act committed as part of that widespread or systematic attack. And the acts are murder, torture, rape, inhumane treatment, deportation, enslavement, or other forms of attack. So an act is any course of conduct which may involve a single or multiple commission of acts against any civilian population, conducted pursuant to, in furtherance of a state or organizational policy to commit such an attack. So I know that some of this sounds convoluted, it's legal, but it's important to say, because it then captures, and people can make up their own conclusions or draw their own conclusions whether what happened in Matabeleland were attacks that were widespread or systematic. A very important part of crimes against humanity is the policy element. A random act cannot be a crime against humanity. You can't, if somebody goes and kills people in Zarabani and says, I'm here to kill Shonas, or I'm here to kill these people from Zarabani, you can't say it's a crime against humanity. There has to be the policy element, so that the crime has to be pursuant to a state or organizational policy. It's a defining feature of a crime against humanity. And in analyzing Gukurahundi, one has to then look at it and say, well, was there a state or organizational policy? My conclusion is that there was. And my conclusion is that what happened in Matabeleland were crimes against humanity. There's ample jurisprudence from the International Criminal Tribunal in Yugoslavia, in Rwanda, the International Criminal Court in Sierra Leone, in Cambodia, in East Timor, to substantiate this conclusion. That when one looks at what happened in Matabeleland, there was a clear organizational state policy to deploy the Gukurahundi to go and, as I said, destroy, persecute, weaken the ZAPU supporting Ndebele community. And the efforts to implement that policy were the training of the brigade, the resourcing of the brigade, the deployment of the brigade, the support of the brigade, the political support, the defense, everything that went into that. Mugabe supporting it, threatening people, the rallies, everything was towards that policy. The role of the political military leaders at the highest level, from Mugabe himself to the commanders, the extent of the military financial means deployed, a whole brigade, over 3,500 soldiers with different regiments of about 1,000. But on top of that, the Zimbabwe National Army had already deployed the 3rd, 4th, and 5th Brigade already to Matabeleland. So the levels of deployment and organization of resources and people towards this policy cannot be disputed, cannot be doubted. the level and involvement of senior people cannot be disputed. They were speaking for themselves. Mugabe was not speaking through anybody else, denying that this was happening, telling the 5th Brigade to do more. And his security ministers, his soldiers, his commanders, it was very clear, his police chiefs and so on. And there is no question that over a period of time, there was repetitious commission of crimes committed in a uniform way. Mass beatings, mass executions, mass disappearances, abductions, detentions, torture, against the same civilian population in Matabele. The same, it wasn't a different one. And the Midlands, of course, I should say. So I will move on. A quick conversation about what is the civilian population. That's fairly simple. The jurisprudence is clear. Civilian population is anyone who's not, taking part in an armed conflict scenario. A civilian is anyone who's not taking part in hostilities. So anyone who's not a soldier, who's not a dissident, who's not a rebel is a civilian. So there's no debate. There's no need to belabor that point. And when we talk about population, we don't mean the whole population. It could be a part of the population restricted by geographical territory for a population to be deemed to be a civilian population. So I'm not going to go into any further detail about that. Suffice to say that my conclusion is that the people of Matabele constitute a civilian population for purposes of crimes against humanity. And then, of course, the last crime is war crimes. I've already spoken about internal armed conflict and international armed conflict and the implications of that particular finding on whether war crimes have been committed or not. Now, if one concludes that the involvement of South Africa and Super ZAPU turned that conflict into an international conflict, one concludes that, and I'm inclined to do so. There are arguments for not doing so as well, and I pretty much respect those arguments as well. If one concludes that the involvement of South Africa turned it into war crimes, then it means that then, as I said earlier, the obligations of the Geneva Conventions kick in. And basically war crimes are any of the following acts which are committed against civilians during an armed conflict. These are what war crimes are defined as. So any of the following acts, if they are committed against civilians during armed conflict, international and national. So violence to life and person, in particular, murder of all kinds, mutilation, cruel treatment and torture, taking of hostages. I had mentioned this earlier, I believe, in the context of Rwanda. Outrages upon personal dignity, in particular, humiliating, degrading treatment, and the passing of sentences and carrying them out without any trial or judgment. So those are war crimes. So these crimes, and I encourage you to reflect back on what Kuguraundi did and see whether there was violence committed, there was murder, there was mutilation, there was cruel treatment, there was torture, there were outrages on dignity, people were executed without any sentencing or any trials, there was humiliating treatment, degrading treatment, there were rapes, there were so on. So you can then draw the conclusion whether any of those things apply. And if you draw the conclusion that there was an international or internal armed conflict, then it takes you to the logical and inescapable conclusion that war crimes were committed in Matabele. That is, of course, if you conclude that Matabele land was a conflict, an armed conflict. I'm going to wind up the last point of my lecture, and I'm sorry it has gone longer than it should have. But it has taken us so long about the law on Kuguraundi, and I guess we may as well just finish. What does this all mean then? What are the implications of all this? So if one finds that Zimbabwe is enjoined or obliged to respect international criminal law, especially because it is part of our law, customary international law, if one finds that Zimbabwe is a party to some of these important conventions that govern international criminal law and humanitarian law, if one finds that the Matabeleland conflict was an armed conflict, or even if they find that it wasn't, if one finds that the crimes that were committed by the Kukurahundi constitute violations of these core international crimes of genocide, crimes against humanity, and war crimes, if one finds all these things, what does this then mean? What are the implications of all this? Far from a political conversation, what are the legal implications of findings of international obligations to respect international law regarding international crimes? The law is very clear. There is individual criminal responsibility for international crimes. I read out an excerpt earlier from Nuremberg, which said that it is time, and it was time back then in the 1940s, to hold individuals accountable, not states. Because as you recall, the Nazis were operating as the German government. But it wasn't Germany that was put on trial. It was Hitler, who cowardly committed suicide, and all the others, Hess and all the others, Streicher, the judges. They were, if you take time to read the Nuremberg judgments, doctors, judges, industrialists, politicians, media, they were all tried. They were all tried by Nuremberg for their different roles in sustaining that genocide. So the fundamental point, customary international law provides for individual criminal responsibility for international crimes. And it sets out two forms of criminal responsibility. So there's individual criminal responsibility, which is the responsibility of an individual for participating. And I'll talk about this. So there's two. Let me first talk about the two types of criminal responsibility. So international criminal law, they provides for accountability for atrocities, accountability for perpetrators who commit atrocities. That's a customary law provision of international law. But the involvement is weighed. The involvement in perpetrating international crimes involves the weighing of various levels of responsibility. And there are two, as I say. There's individual responsibility, and then there is command or superior responsibility. Individual responsibility is, as it says, individual. It's what an individual has done towards the perpetration of a crime. I'll talk about the forms of perpetration, modes of perpetration or participation. Command or superior is a vicarious responsibility. It's actually almost cited as a commission by omission. It's what you fail to do as a commander. So you don't need to be on the ground even for command responsibility or for superior responsibility. Nobody needs to say, I saw them here, they did this. No. Command responsibility is responsibility for failing to prevent and punish, to prevent, investigate, and punish your subordinates who commit crimes. So it's a very important distinction. So there's individual responsibility. Somebody commits a crime, somebody incites the commission of a crime, and the forms of responsibility, the modes of participation are as follows. So you can plan a crime, you can instigate a crime. Like if you say, oh, go and kill those people, you're instigating a crime. You can order a crime, go and commit this crime. You are a commander, you are a prime minister. And this is exactly what happened with Mugabe. You can commit the crime yourself, go there on the ground and kill dozens of people. You can also aid and abet in the planning, preparation, or execution of a crime. So what does aid and abet? You drive the car. That takes the people who are committing the crimes. You park your car and you wait while they commit the crime. You are aiding and abetting. You could also actually be part of the crime. It could actually also be concluded that you are a perpetrator, a direct perpetrator of the crime. You could provide the money for the crime. You could provide resources for the crime. You could also help in the planning. You could come and say, oh, no. This is the bomb that will kill the most people. If you really want a bomb that will kill people in Matabele, and here is it. You could come up with the plans. You could come up with the ideas. You become complicit in that crime. You don't need to be on the ground. You can incite the commission of a crime as well, like the journalists in Rwanda who were telling people that there are people in this place, please go and kill some more. There are some Tutsis hiding in this place. So they were aiding, abetting, but they were most importantly inciting. And this is one of the most dangerous crimes ever, the incitement of a crime. So when it comes to command responsibility, I'll go back. It is not necessary for the person accused or alleged to, as a commander or a superior, to be at the crime scene, to perpetrate the crime themselves. It is enough to simply show that they were in a position of command over the subordinates and that they were aware that the crimes had been committed or were about to be committed and they did nothing. That is enough to sustain a charge or a conviction on command responsibility and superior. The difference between command and superior responsibility is that command is for army, is for military, people in command, military, and superior is for civilians. So as such, Kambanda, the prime minister in Rwanda, was found guilty on the basis of command and superior responsibility. So was Akayesu and others, even though they were also found guilty on the basis of individual responsibility, because they were also inciting in other instances. So it is possible to find somebody guilty as an individual, but also as a commander. So I think I'm done with my lecture, dear colleagues. What does this all mean at the end? International law also imposes, international and national law imposes an obligation to investigate, prosecute, and punish the commission of any crime. We know that in Zimbabwe, if you commit a crime, there is an obligation for the police to investigate and for the prosecutors to prosecute and for you to be punished. We know that. We know that that is a national obligation under criminal law. It is also an international obligation that any perpetrator of an international crime must be investigated, prosecuted, and punished. That is a requirement. But that's not where it ends. Many have asked, well, what about the ICC? Zimbabwe is not a party to the ICC. It's not. It signed and then it backed off. It didn't ratify it. So the ICC is a creature of treaty. The only people that are subject to the ICC are the people that are state parties, but there are exceptions. The ICC can also extend its jurisdiction to people that are not state parties, only when the Security Council, the UN Security Council, asks it to do so. But there's another challenge anyway, and nuance. The ICC only has jurisdiction over crimes that were committed after it came into place. So we must make it clear that the ICC has no jurisdiction over Kukuraundi. None whatsoever. It doesn't. And I know people have said, oh, why don't you take them to the ICC? Why don't you? You can't do that. You can't take anybody from any country, whether it is Zimbabwe or Mozambique or America or Afghanistan, to the ICC for any crime that happened before the ICC was established. You can for crimes that happened after via a Security Council referral. There's another way in which the ICC can get jurisdiction. That's why Bashir was referred to the ICC when Sudan was not a party to the ICC, because the Security Council referred the genocide in Darfur to the ICC for investigation. And it was investigated, in fact, by my good friend, Esafar, who was at the ICC at the time. And the warrants of arrest were sought and obtained for Bashir and his comrades. So, but what does that mean? Is that the end of the conversation? By all means, no, it is not. Ultimately, the enduring responsibility for accountability persists, just like it persists in our own national and domestic context where a crime has been committed. People will always be asking, what happened to that guy who killed his wife? What happened to that guy who raped that woman? Did the police ever finalize it? Sometimes the case drags, sometimes it doesn't. Sometimes the police don't investigate, sometimes they do. But ultimately, the point is that once a crime has been committed, responsibility immediately ensures, and the obligation immediately sets in. So that is the law. I'm not talking about the politics. The politics can then address other things, including how do you deal with crimes that happen in a country over a period and they leave a country with a legacy of brokenness. That may require a combination of legal and political solutions. And I'm done with the law. I'm now on other issues, and I'm going to close now, Zenzel. So that's the law, dear colleagues, on Bukraundi. If you ask me, so what next? I'll say, well, the bottom line is that the law is clear. The law is clear about the crimes, about the perpetrators, about everything. The law is actually quite clear. There might be some gray areas when one talks about was it a conflict, wasn't it a conflict, etc. But it doesn't matter, because even if there are no war crimes, even if it wasn't a conflict, there's still crimes against humanity and genocide. So it really doesn't matter. But so what? That solution, in my opinion, may lie in politics rather than in the law. Given a number of factors, the reality is this, right? The reality is that no matter what happens, hanging over the heads of any perpetrator is the prospect of prosecution for these crimes. Because I've highlighted what the law says. That's what the reality is. The law is clear on this. And at any point in time, mind you, crimes against humanity, war crimes, and genocide are not subject to any statute of limitations. What does that mean? Statute of limitations is you have a certain time frame within which you can prosecute a crime. If you don't prosecute it within a certain time frame, you can no longer prosecute it. So many crimes have a statute of limitations. So it's 20 years sometimes. If you commit a rape and nothing happens to you for 20 years, and 20 years later, sometimes a report is made, it can be subject to statute of limitations, which means that you can no longer be prosecuted because the time has lapsed. There are some crimes that are not subject to statute of limitations, like murder, for example. I need to be corrected, and the criminal lawyers can tell me. But the point here is that none of the international crimes are subject to any statute of limitations. Those crimes remain live forever, which for me suggests that what is really required, therefore, is urgently and most importantly, a political solution, mixed legal and political situation to this Bukraundi issue. Because as long as that doesn't happen, these crimes hang, they hang over the legacy of the crimes, hang over the victims themselves. They live it every day. They live the pain, they live the loss. but they also hang on the perpetrators. These crimes are hanging on the perpetrators. And perpetrators are only able to evade accountability by virtue of political incumbency. And that is a shame, in the sense that if I were a perpetrator, I would seek to resolve this issue rather than hang on it just because I'm in power. It is a very precarious situation to rely on, because power can shift very quickly. And if it does shift, then you're facing the full might of the law. Whereas it is possible, because it has been done before. In other countries, a solution can be reached for these crimes that mixes both legal and political aspects, that allows the country to move forward, that places into context, that values and respects victims, that allows perpetrators to take some responsibility and some accountability, and that compensates victims for the suffering they have felt and acknowledges their pain. And that sets in motion steps to make sure that such horrendous and barbaric crimes never ever happen again. The country can still move on with such a solution. But I say this now, obviously, having discussed the law, that it is as much an imperative for perpetrators to resolve Kukuraundi as it is for victims. I repeat, it is as much an imperative for perpetrators to resolve Kukuraundi as much as the victims, because things can change, and usually things do change. And when they do, you want to be able to have resolved this issue. And that's all I want to say. And thank you so much, Zenzele. Thank you, colleagues, for giving me so much time. I know it ended up being too long a lecture, but that's what it is. That's the law on Kukuraundi. And I've given a sense of my sense of what might be done. Thank you.
Thank you, Sipho, for that lecture. And I hope that people have learned something, but also we always get questions to say, why can't we take the people to the ICC and so forth. So being a journalist and not being a lawyer, I still ask myself that basically you are saying, yes, an international crime was committed, but currently we can't do anything unless there is change of circumstances. Then the case can be tried in international law.
Well, I can answer this question. No, not exactly. There is an international obligation to prosecute crimes against humanity wherever they occur. So it's actually quite possible that any other country could prosecute any of these crimes, or any other tribunal set up. The question, of course, is this likely to happen, right? Because there's what you might desire or wish, but there's what is possible. Remember that the international community set up the International Criminal Tribunal for Yugoslavia. They set up the International Criminal Tribunal for Rwanda. Is it likely that the international community will set up an International Criminal Tribunal for Zimbabwe? I doubt. It could be possible, but I doubt. But is it possible that the perpetrators could find themselves tried at some point, in some way, in some country, exercising universal jurisdiction? It's possible. But is it possible for Zimbabwe to resolve this issue itself? Absolutely. And will the resolution satisfy everyone? Probably not. But might it make the country move forward? Might it allow the victims to feel acknowledged? Might it help address the legacy? Possibly. And I'm at this point not talking law, right? I'm talking about some of the creative solutions that other countries saddled with these horrible, violent pasts have sought to use. South Africa is one, and there's a lot of criticism and debate about whether it was useful to go that route. I mean, I'm one of those people that feel that people like de Klerk got away with murder. But South Africa made a choice because de Klerk was implicated in these crimes. But they were willing, he's one of those who wasn't willing to admit, sadly, and got away with it. But they were willing, many of them, and then the Truth and Reconciliation Commission was an avenue to steer. But there was some truth-telling, there was some acceptance, there was some acknowledgement. People came forward and said, yes, you know what, yeah, we did this. Yeah, we're sorry. And it was clear that if you do that, what are the implications? And it allowed the country to move forward. Of course, some people will say, did it really move forward? And there's many commissions that have happened in Argentina, in Latin America as well. Even in East Timor, as I was defending these militia commanders, we had running parallel to this process, we had the Truth and Reconciliation Commission in East Timor, which dealt with people who were willing to come forward and confess, and the communities would say, okay, fine, we forgive you, come back. So there was, but what I'm saying ultimately is that this is not a cut and dry story, right? It's not an either or. This sword of the axe of Kukraundi is hanging over everyone, over the victims of Kukraundi, but also on the perpetrators. And the perpetrators must, because the perpetrators are in power, they have an incentive, in my opinion, to resolve it. Then they can sleep. And then maybe we might even begin to have possibility for political change as well. Because obviously one can't even ignore the possibility that part of the hanging on to power might be related to the fear of what happens if I'm no longer in power. So some of these are not legal questions, they're political ones. And I didn't intend to make this a political conversation, but that's my answer, Zenzel.
Okay, thank you. I'll just take about 3 burning questions, then we'll end it. I'll ask those who want to ask questions, not to be too long, not to give us another lecture. We just want brief questions, then Sipho will answer those. So we'll take about 3. We'll also try and read some of the comments. So I'll pick Pilani Zamchia, Togo Mkwanazi, and Dr. Skwili Ngube in that order. So let me, okay, I have to unmute them. So I was trying to just have order. So please unmute yourselves. I've requested that you unmute, then you can ask questions. Zamchia, you can go ahead.
Thank you very much, Zenzele, for the useful program. Sipho, I think that was a very powerful presentation, really top grade. I just have a question here. There are quite a number of scholars who argue strongly that Kukraundi was not a genocide. It wasn't about the liquidation of a particular ethnic group, Ndebele to be specific. What's your view on that, given your rich study? Thank you.
Okay, let me give Togo to go ahead, then Doctor.
Thank you so much, Zenzele and Siphosami, for this amazing presentation. I cannot, words are not enough just to express my gratitude for the work that was put behind enlightening us on this very important subject that is very dear to all of us. I guess my question really is, I like to really think about the practical steps that we can take now that we've been informed and we're not approaching this from a political or emotional perspective. I'm really interested in knowing, what will it really take, for this crime to be presented before the International Criminal Court? What are those actions? Siphosami talked about all these cases that have been presented. Someone must have taken the initiative to ensure, these cases were presented and were addressed. And that, for me, is really my question. What will it take? What is our responsibility in this to ensure that happens? Thank you. That was my question.
Okay, Dr. Ngube again, go in, then Sipho will try and respond to the 3 questions. Ngube, I've asked you to unmute your mic. You can go ahead.
right, thank you. So I was struggling to unmute myself here. Thank you for the lecture, Sipho, and thank you, Zenzele, for the platform. My question, perhaps, and this is a conversation that Sipho and I have perhaps had on the sidelines, concerns evidence, issues to do with evidence. And he has indicated that we categorize perpetrators, and there's the issue of command responsibility and so forth. Now, looking at the time that it has taken since Kukuraundi was perpetrated and where we find ourselves now, do we have sufficient evidence? Because my feeling is that we could possibly, through other mechanisms, find that a tribunal or a special platform has been created to try those who are accused of having perpetrated these horrendous crimes. But when it comes down to it, it's the evidence is not sufficient. And I say this because Sipho was very careful to say this lecture limited its scope to the law. And you'll find that there was a lot of definitional elements of what crime, genocide is and so forth, which is all well and good. But when it comes down to it, can we point fingers now? We often heard of parents, Shiri is out now. Who can we say so and so can go before a tribunal and be convicted? So my question, perhaps to sum up to Malunga, is what is the evidence that possibly could be put together for purposes of prosecution? And I'm not talking of evidence of atrocities, because the mass graves were marked, everything is documented, but I'm talking in essence in relation to individuals. Thank you, Zenzele.
Okay, Malunga, you can go ahead and answer the question.
Okay, I'll start with Pilani's question. So Pilani, yeah, I know that the scholars that have said it wasn't, but they haven't said why it wasn't, right? I've said why it is. So from the very onset, I'll give you a quick rundown. From the very onset, the allegations of the genocidal nature of the Kukuraundi were raised by ZAPU officials, by victims, by journalists, by political analysts, by diplomats. From the very beginning, and if one looks at victims' accounts, if one looks at the media at the time, reports that were done, there was always a Ndebele dimension, you know, to the allegations. I mean, let me give you one quotation. Edson Zobo, Minister of Justice, this is what he said. While some whites were affected, this is Edson Zobo at the time of Kukuraundi, just before when it started, 1980. While some whites were afflicted by the withdrawal from power syndrome, on the other side of the coin, some Ndebele Zimbabweans viewed Mugabe's victory as unbearable power denial, which had somehow to be reversed. You know, this is the Minister of Justice, a kingpin, a senior politician, a senior minister in Mugabe's government. I can go on. I mean, there's so many of these. Sekaramai, you know, Nkala. There are so many, Mugabe himself. So the question, ultimately, an evidential one, right? Even as I say so, it doesn't make it so, right? I'm doing my own analysis and drawing my own conclusions, analyzing the facts, the context. Ideally, a finding of whether something is genocide is done after an inquiry by a court. But my conclusion, having analyzed the facts, is that it was a genocide. The genocidal plan was clear. And Mugabe, to make matters worse, Mugabe, just before he died, he confirmed it again. Had he said, no, it was just Nkomo, I would have accepted. But the guy said in Ndebele party, what does that say to you? So these scholars that are saying it was not a genocide, I challenge them to tell me why it wasn't. I've said why it is. And I've got not just one. For goodness, I've got like dozens and dozens of examples of all these senior officials alluding to the Ndebele nature of the victims. And mind you, when the 5th Brigade was deployed, they were clear what they were going to do. They were going to kill Ndebeles who support ZAPU. So let's not obfuscate the issue of Ndebeles by saying, oh, it was ZAPU. No, it was together. But ultimately, the target was Ndebeles. Yeah, anyway, the second question, how do you think ICC? I've already said it's not possible, Sistogo. The ICC jurisdiction is constrained by that treaty. The coming into force of the ICC, only crimes that were committed after can be tried. Only crimes that are committed in relation to state parties can be tried. Kukuraundi happened before. Zimbabwe is not a state party. So it's not possible to take the ICC, Kukuraundi to the ICC. That is the law. That doesn't mean that it's not possible to hold Kukuraundi perpetrators accountable. It doesn't. There's always been many different ways in which perpetrators have been held accountable. Remember that when in the Yugoslavia, before the atrocities there was nothing like an international criminal tribunal for the former Yugoslavia. It was created for that. In Rwanda, it was created for that. There was none created for Kukuraundi because at that time, the ethos of the international community seems to have been different. Remember, there was similar atrocities happening in Latin America as well at the time of the Kukuraundi, exactly the same way. Pinochet and all those guys, all those dictators in Latin America were committing similar crimes in almost a similar fashion. But the question still is, where there's a crime, there remains an obligation to resolve it. So it doesn't change anything that the ICC can't deal with it. I don't hold out too much for the ICC. There's so much things I don't like about the ICC. My friend is the new prosecutor there, Karim. But there's history and there's issues in the ICC. But I still believe it's necessary. The ICC is absolutely necessary in this world where we live in. But the ICC is out of this. The ICC may be in for crimes that happened after it came into place if those crimes are then brought to its jurisdiction through the other ways in which jurisdiction can be gained by the ICC. Prof. Mube, hey, you are right. Evidence will always remain the critical element in any criminal process. We know that. I mean, you cannot have a process without evidence. But we must also accept that for crimes of this nature, the courts have taken a more expansive way of assessing and analyzing evidence. So it might very well be that the specific individuals, if they can be found, they may be found. But if they cannot be, sometimes the people who may have orchestrated, planned, ordered, may be the ones. There's enough evidence of these crimes being planned, being executed, that it may very well be possible if at least some of the perpetrators are identified and found to hold them accountable. I do agree with you that over time, evidence gets lost. And we say, well, witnesses die, the location of crime graves or crime graves, they degrade. I mean, mass graves or graves, they degrade. People who were there, their memory gets weakened. But the truth of the matter is that the nature of these crimes are such that they cannot be forgotten easily. So the witnesses that remain, and there were many, remember that many of these crimes were committed in full view of entire villages, which meant effectively that the little children were there all the way to the adults. And the people that were usually killed were the adults, but the children remained. And many of these children are aged anything between 40 and 50. So the witnesses are still there. And in a criminal case, what do you need? Just a witness. Just a witness. That's all you need. And the court will have to make a decision whether they believe the perpetrator or the witness. But if 3 or 4 people say, I was in this room and Zenzele walked in and he killed 5 people, and Zenzele says, no, I didn't do it, well, ultimately the court will have to decide who it believes. So for me, I hear you on the evidence, and yes, it is a legal issue, and it's an issue that would have to be resolved. But like I said, I really hope that there is a more circumspect way of viewing Guguraundi and seeing the necessity for resolving it, so that people are not left in a situation where they are clutching at, oh, maybe we can do this, maybe we can do that. The government needs to take serious steps to try to resolve it, despite the fact that the perpetrators are in government. And I believe that there may be support for such an effort, a meaningful effort, an honest and meaningful effort, not one that seeks to whitewash Guguraundi, because it can't be whitewashed. It's not possible. It's just like crime. It's there, you know? Thank you.
Okay, thank you. Maybe there's someone who asked whether Guguraundi was a genocide. I find there's, if you know the book by Stuart Doran, Kingdom, Power, Glory, Stuart quotes diplomatic sources. And on page 415 and page 450, there is something interesting where he says Zobo talked to Siphosami, who then reported to the Australians that there was a Central Committee meeting on December 1982 where ZANU-PF resolved that they should massacre the Ndebelets. And if we go by that, if there was a ZANU-PF resolution to massacre the Ndebelets, it makes it a genocide. If you also look at the British cables, which are now declassified during Thatcher's time, Sydney Sekeramai tells the British embassy that the Matabeleland situation is a Biafra situation. So if he talks about the Biafra situation, he says these people want to secede. So we have sent the army to deal with them. But also I found that there is a memo which was written by a police officer in Plumtree, was officer in charge then. So he writes this memo and he sends it to the army guys in Bulawayo, and he says, can you please bring in soldiers so that we can go to Mlomwe area? The people in this area need to be sorted. We need to sort them. And sorting them means beating them up. He says we need to beat them up because they seem to be supporting dissidents. Subsequently, the army and the police had a joint operation there. 17 villagers were taken to Plumtree and they were sorted. So I think over the years, there have been a lot of declassified information that actually points to the fact that Guguraundi, more than anything else, was a planned genocide. Let me say at this point, we are on generator because there was something wrong with ZESA. And my fear is in the next 10 minutes or so, our power might run out. So I'll take the last 2 questions, Nkala and Luanle. Comrades, just be brief and then respond, because I'm afraid we've been running on the generator since 8 a.m. Or 7, so we might be running out of fuel now. So I don't want it to just switch off. Then we won't be able to save this conversation for people to view it later. The conversation or the lecture is there on YouTube and on Facebook site ZW. I know some people are on Twitter and the sound is not perfect. So those who are on Twitter and you want to listen from scratch, you can go on our Facebook page, you can go on our YouTube page. That's where the conversation will be. So let me unmute these 2 and just ask brief questions, then we can conclude. So I'll start with Ngala, then I'll go to
thank you very much for attending this lecture. But my question is on, can we map up an action plan to try to get this to another level where we can actually have a resolution, like take it to the UN or wherever it can be taken? And I was also asking, is it possible uMalunga sibe naye kulokhuzeni kuma spaces akayichaze kahle lento, because as the others are saying ukuthi there are some scholars that are going around and saying that it was not, but we are starting to discover also that there is quite a lot of people that do not know what is a genocide in actual fact. So there is a debate which I can say is more political than factual. Thank you very much.
Zenzele, is that the only question? Should I answer that?
There is Luandle. I've asked.
Hello.
Okay.
Yes, go ahead.
Hello. Good
ahead,
evening, gentlemen. Okay. Is it possible for as Ndebeles that we open up a trust fund so that we can gain some funds to persuade this case of genocide, so that those perpetrators they can brought to account, especially if, let's say, if they pass away or so whatever, and then we follow up to their relatives.
Okay, let me see if I can answer both questions. So, I think that Nkala, my presentation did address what the possibilities are and the prospects are. Yes, you can take it to the UN, but my view is that it's less likely to be as helpful at this point. I believe that ultimately the responsibility for resolving Kukuraundi rests on the people of Zimbabwe. That's my own belief. But the reality is that Kukuraundi remains as an X hanging over everyone's neck. Not on the people who were killed, because they were killed already, but on the perpetrators and the victims that remain behind. So there is an imperative to resolve it, and we need to go deep into our reservoirs of sensibility to try to resolve it. I believe that it's a bigger problem for perpetrators than it is for victims, in my opinion, because perpetrators have to live with the real fear one day of being held accountable. Yet, they could, in a meaningful way, seek to address Kukuraundi. Other countries have. It's a difficult thing to move past these difficult periods, not necessarily arguing one way of resolving it over another, but we are recommending and arguing for a really open mind, but also genuineness and honesty in the engagement by alleged perpetrators. And Luandle, I mean, yeah, I know that maybe a controversial point. Yes, Kukuraundi was a genocide and it did kill Ndebeles. But I believe that ultimately the resolution of genocide of Kukuraundi must be a national one. Kukuraundi happened in the context of a national political discourse and tension and conflict. And it must, the resolution, because what Kukuraundi has left behind is a divided country, a broken country, and a country which has a culture of impunity for human rights violations. I believe that it is impossible to resolve Kukuraundi only as one ethnic group. It's impossible. What resolution are you achieving? There are so many people who are non-Ndebele, who had nothing to do with Kukuraundi. They didn't commit any genocide of anyone. So, and I'll say this openly, and I'll repeat it many times. There are so many people who are Shona who didn't kill anybody. Why should they carry the burden of Kukuraundi? Why? They shouldn't. The people who perpetrated Kukuraundi should help us all unburden ourselves from Kukuraundi. it becomes very easy to paint things in brushes. That's exactly what ZANU-PF did. They painted everyone in brushes when they committed Kukuraundi. Do we want to paint everyone in a brush again? Where does it end? I believe that Zimbabweans should come together to all collectively condemn Kukuraundi. There is no sane person anywhere in the world who can defend Kukuraundi. No sane person. Regardless, even if it was to be, even if the target was somebody you don't like. But because we had Kukuraundi, we had Mrambatsvina, we had 2008, we keep having these crimes because we are willing to say it was okay to do it to Ndebeles. And then later on it's done to white farmers. Then later on it's done to MDC. Then later on it's done to journalists. Then later on it's done to human rights activists. Then it will not end. Let's draw a line collectively and say this in our national consciousness is unacceptable. And we will not do this ever again. We will not accept this to be done to anybody ever again. That is the real test of an inclusive society. How the minorities and the most marginalized are treated is how you can measure a society, not by how the majority are treated. They already have an advantage and a privilege. So it's an important point that we must make, and we must draw that line. I'm not so worried because the perpetrators are old. Many of the people who were in government at the time are old. They're in their 70s, 80s. It is the legacy they are going to leave for this country. And many have died without having ever been accountable. The number one perpetrator of Kukuraundi is Mugabe. He's dead. So even if one was to say, okay, we're now holding people accountable, to what end? It might very well be that many of the other people that were below were just taking instructions and executing them very diligently. But you've already lost the people most responsible for this. The man who was commanding the brigade is dead. Shiri. There's some who are alive. Chimonyo came back, the others who then died later. So, but you look at it. But the problem of Kukuraundi will never go away, even if they all die. That is the problem for me. And that's why I'm really motivated that there has to be a solution to this issue. Thank you, Denzel.
Thank you, Babu Malunga, for this talk. I think it opened our eyes. It also brings a different dimension to this whole Kukuraundi issue, because it has always been about, the politics, the talk on Twitter, social media, on WhatsApp groups, insulting each other. And I think people need to realize that it was the government of Zimbabwe at that time that decided to deploy the 5th Brigade and to kill people. And the government of the day is still in power and is responsible. So I want to thank everyone who joined in. Like I say, the conversation is on Facebook, it's on YouTube. Apologies for the Twitter sound. Many people were sending us messages saying the sound is not clear. Next time we'll do better. And like I said, we are in Zimbabwe where electricity is always a problem. So we've gone for 4 days now without electricity because something was stolen. So we just want to end this on time so that we are able to save the files before the generator runs out of fuel. My name is Zenzel Ndebele. Have a good day.